Question: Equality in admissions to educational institutions and in matters of public employment in the light of Son of Soil theory. Question: Bring out the various reforms that keeps the administration on secular lines. Question: How far childhood happiness could be ensured by constitutional means? Question: Law reflects the socio-political culture of people. Question: Religion is the opium of the masses. Marx. State how far religion has spread fissiparous tendency in the society. Question 1. Equality in admissions to educational institutions and in matters of public employment in the light of Son of Soil theory. The Constitution, 86th Amendment, Act 2002 inserted Article 2(1) in the Constitution of India to provide free and compulsory education of all children in the age group of 6 to 14 years as a fundamental right in such a manner as the state may, by law, determine. The right of children to free and compulsory education, RTE, Act 2009, which represents the consequential legislation envisaged under Article 2(1) means that every child has a right to full-time elementary education of satisfactory and equitable quality in a formal school which the 6 to 14 age group. With this, India has moved forward to a rights-based framework that casts a legal obligation on the central and state governments to implement this fundamental child right as enshrined in the Article 2(1) of the Constitution, in accordance with the provisions of the RTE Act. The RTE Act provides for the right of children to free and compulsory education till completion of elementary education in a neighborhood school. It clarifies that compulsory education means obligation of the appropriate government to provide free elementary education and ensure compulsory admission, attendance and completion of elementary education to every child in the 6 to 14 age group. Free means that no child shall be liable to pay any kind of fee, charges, or expenses, which may prevent him or her from pursuing and completing elementary education. It makes provisions for a non-admitted child to be admitted to an age-appropriate class. It specifies the duties and responsibilities of appropriate governments, local authority and parents in providing free and compulsory education. Prohibition of deployment of teachers for non-educational work, other than decennial census, elections to local authority, state legislatures and parliament, and disaster relief. It provides for appointment of appropriately trained teachers, i.e. teachers with the requisite entry and academic qualifications. It prohibits a. Physical punishment and mental harassment, b. Screening procedures for admission of children, c. Capitation fee, d. Private tuition by teachers and e. Running of schools without recognition. It provides for development of curriculum in consonance with the values enshrined in the Constitution, and which would ensure the all-round development of the child, building on the child's knowledge, potentiality and talent, making the child free of fear, trauma and anxiety through a system of child-friendly and child-centered learning. The Constitution of India provides various fundamental rights in Part 3, under which Article 16 provides equality of opportunity in matters of public employment. Article 16 is provided to all citizens of the country. Article 16 covers the following aspects. State can also do a reservation for promotion and consequential seniority of SC, STs. State can make the separate classes of vacancies from the unfilled vacancies of year for determining the ceiling of 50% of reservation on total vacancy. Scope of Article 16. Article 16 deals with public employment, which means employment or appointment to any office under central or state government or subordinate to them. Now, matters relating to employment and appointment must include all matters in relation to employment both prior and subsequent to the employments which are incidental to the employment and form parts of the terms of the conditions of such employment. The expression, equal employment opportunity, is having a wider scope. The phrase equal employment opportunity, EEO, includes access to jobs, conditions of employment, relationships in the workplace, the evaluation of performance and constitutional authority of the High Court. If rules are not in consonance with the philosophy of our Constitution and the same may be modified and no appointment in contravention thereof should be made, it is necessary that there is strict compliance with appropriate rules and the employer is bound to adhere to the norms of Articles 14 and 16 of the Constitution before making any recruitment. In the case of Food Corporation of India v. Bhanu Lodh, it was observed that any discrimination can only arise as between the persons who are similarly, if not identically treated. It is not possible for the deputy manager's post to claim that he had been discriminated against because a joint manager had been appointed. There is nothing common between the two posts. It is perfectly valid for the employer to fill up one category of posts and decline to do so the other for various business reasons. The argument of discrimination is without basis or merit. Public employment and son of the soil theory. Public employment refers to employment in state-run institutions. In most cases of public employment, there are reservations with regard to the classes considered backward in nature. This classification is based on various criteria that are put forward in the Constitution. These reservations are seen as a way of providing overall backwardness of the communities. However, in the case of K.C. Vasant Kumar v. State of Karnataka, the court took a different stance. The court held that economic backwardness alone is not a condition for backwardness, social backwardness, and historical injustices also form a major part of it. The progress made by every community should be checked. If the community has progressed enough to compete with the general public, then they should be removed from the list of backwardness. These were the main cases with respect to public employment and equality of opportunity. Son of the soil theory is a theory that puts forward the idea of reservation based on regionalism. A particular state is considered to be the homeland of the main linguistic group residing there. This theory is based on the idea that the primary responsibility of a state is to protect its citizens. This theory is applied more in states where there is a large population of migrants. It is a way of giving an upper hand to the locals over the migrants in employment opportunities. This theory is in accordance with the provisions of Article 16(3) of the Indian Constitution, which extends to the state government the power to make laws that give special provisions to the people of that region. Outside Madhya Pradesh had to pay a capitation fee. The main issue that arose was whether Article 15(1) was violated. The provisions of Article 15(1) prohibits discrimination on basis of place of birth. The court held that the practice was not violative of article as the domicile practice was reservation on basis of place of residence, not the place of birth. In the dissenting opinion, it was said discrimination on basis of place of residence is the same as discrimination on basis of place of birth. However, a different perspective was adopted in the case of Mohini Jain v. State. collect excessive capitation fees from students of other states taking admission via a private seat. The students procuring admission via government seat had no capitation fee, and the Karnataka residents opting for private seats had a low capitation fee. When this matter was taken to court, it was seen as a violation of the right to education. The court held that the classification was not valid as everyone has a right to education. The right to education was brought under Article 21, the right to life. The courts initially gave importance to theories like son of the soil theory, but when they have been found violative of other constitutional provisions and concerning secularism, Art. 14 grants equality before the law and equal protection of law and provides that the state shall not discriminate against any person on the ground of religion. 2. Practice of bigamy. One of the cardinal principles of secularism incorporated in the Indian Constitution is that the state is not to take sides in matters of religion. The prohibition of the practice of bigamy among the Hindus, even though these provisions are not applicable to Muslims. It is not necessary under Article 14 of the Constitution that any legislation that the state may go on upon. The state may rightly decide to bring about social reforms by community-wise. Therefore, bigamous marriage is not uniform. Article 15. Art. 15 provides that the state shall not discriminate against any citizen on the ground of religion in any public place. In Nansukdas v. UP State, the Supreme Court has held ultra vires an act of state legislature which provided for elections on the basis of separate electorates for members of different religious communities. Any law providing for elections on the basis of separate electorates. B. Equal opportunities for citizens in matters relating to employment or appointment to any office under the state. B. Venlatramna v. State of Madras. The Government of Madras passed a communal government order allotting certain vacant posts in government services in fixed proportions to the Muslims, Christians, Harijans, backward Hindus, non-Brahman Hindus and Brahmins. The petitioner applied for the post as district munsip and he was not selected on the account of communal government order. He then filed an application in the Supreme Court praying for the advertisement of the Civil Judicial Service gross violation provisions of Indian Constitution and therefore void. Therefore to cancel the selection, prohibiting filling of posts and examine the case of petitioner on merits without applying the rule of communal rotation. 4. Freedom of profession, practice of religion. Under Article 25 all persons are equally entitled to freedom of conscience and the right freely to profess, practice and propagate religion. Protecting public order, morality and health. The freedom granted from Article 25 is not of absolute nature, the right subject to consideration of public order. 2. Making the law appointing non-Brahmins as Purohits, after giving them the necessary training as Purohits. 5. Temple entry legislation. Some of the laws also aim at removing irrational element in Hindu rituals and religious practices. X. Prevention of Animal Sacrifice Act, Prevention of Devdasi, Harijans' entry into temples, that right had given to enter into temple for purpose of worship. 6. Religious and charitable trusts and endowments. It is well known the religious and charitable trusts have existed in India. The right and liabilities of Shebates and Mohuns have been affected great extent by the provisions of the Constitution. The Supreme Court finally decided Mohand had a right to enjoy that property or beneficial interest so long as he was entitled to hold his office. The right of Mohand to dispose of the surplus income of the Mutha. He is not permitted to spend income for his own personal use. for the purpose of better administration, protection and preservation of the property of Mutha, exceeding 5% of its income for the services rendered by the government and their officers. The tax imposition is the mischief of Article 27 of the Constitution and was void. 8. Secularism and Education. The British government, however, preferred to adopt a policy of neutrality in the matter. In 1882, the Education Commission of 1882 suggested the introduction of textbooks designed to provide education in morals, but the government did not implement the suggestion in order to avoid controversies. The Advisory Board recognized the fundamental importance of spiritual and moral instruction in the building of character will be instructed at the home and the community to which pupil belongs. I. Prohibit in education institution. Article 28 prohibits the imparting of religious instruction in any educational institution wholly maintained out of the state funds. However, this provision does not apply to an educational institution which is administered by the state but has been established under any endowment or trust. 2. Great religious leaders should be studied. 3. Universal truths from the scriptures. 4. Central problems of philosophy or religion should be considered. Secularism and general elections. The system of separate electorates and communal representation has not been recognized in our Constitution. There is one general electoral roll for every. Question 3. How far childhood happiness could be ensured by constitutional means? Understanding child rights in Indian Constitution. Children's rights are human rights that are accustomed explicitly to the children's needs, wants and overall well-being. They take into account their fragility, specificities and age-appropriate requirements. Children's rights aim to take into account the necessity of the development of a child. India, in its bid to become an ethical labor market to international corporations in 1991, ratified the United Nations Convention on the Rights of the Children in 1992. The convention stems from JEB's desire to end the suffering of children, giving them instead a healthy, happy and safe environment that nurtured them physically, mentally, and emotionally. These facets find a strong resonance in the convention. Child rights go beyond just human rights, which exist to ensure fair and proper treatment of people across the world, and promote their well-being. Children, defined as any person under the age of 18, need more than just human rights due to a set of unique needs stemming from their vulnerabilities. Further, the child rights in the Indian Constitution as described in the Convention have been summarized into the following fundamentals with references to various articles. 1. The right to an identity, Article 7 and 8. Children are entitled to a name, legally registered with the government, and a nationality, to belong to a country. Further, they must have the right to an identity, in the form of a public record. This ensures national support, as well as access to social services. 2. The right to health, Article 23 and 24. Medical care, nutrition, protection from harmful habits, including drugs, and safe working environments are covered under the right to health, and Articles 23 and 24 on child rights in the Indian Constitution and elaborate on the access to special care and support for children with special needs, as well as quality health care, including drinking water, nutrition, and a safe environment, respectively. 3. The right to education, Article 28. Right to free primary education is critical for helping children develop discipline, life skills while finding a safe and healthy environment to nurture a child's physiological development. This includes freedom from violence, abuse or neglect. For the right to a family life, Articles 8, 9, 10, 16, 20, 22 and 40. If not family members, then children have the right to be looked after by caretakers. Children must live with their parents until it is harmful to them. However, family reunification, i.e. permission for family members living in different countries to travel to renew contact between family members is critical. Under the ward of a caretaker or family, they must be provided privacy against attacks on their way of life and personal history. Children who do not have access to a family life have a right to special care and must be looked after properly by people who respect their ethnic group, religion, culture and language. Refugee children have a right to special protection and help. In the case of misdemeanors, children have the right to seek legal counsel under a juvenile justice mechanism, with the fair and speedy resolution of proceedings. 5. The right to be protected from violence, Article 19 and 34. Protection from violence extends even to family members, and children must not suffer ill treatment or sexual or physical violence. This includes use of violence as a means of discipline. All forms of sexual exploitation and abuse are unacceptable, and this article takes into view the sale of children, child prostitution and child pornography. 6. The right to an opinion, Article 12 and 13. All children deserve the right to voice their opinions, free of criticism or contempt. In situations where adults are actively deciding upon choices on behalf of children, the latter are entitled to have their opinions taken into consideration. While children's opinion may not be based on facts, it is nonetheless an important source of insight for parents, and should be considered. However, this depends on the child's level of maturity and age. Children have the freedom of expression, as long as they are not harming others with their opinions and knowledge. 7. The right to be protected from armed conflict, Articles 38 and 39. Armed conflict converts innocent children into refugees, prisoners, or participants in armed conflicts, and these are all circumstances which contravene with the spirit of war, or any armed struggle can severely damage a child's morale as well as perceptions of ethics, and this must be corrected in a nurturing, safe environment. While seeking to rehabilitate children affected by war, the government must also ensure that children are not forced to participate in any armed struggle. 8. The right to be protected from exploitation, Articles 19, 32, 34, 36 and 39. As exploitation is usually achieved through violent means, protection from violence is critical for freeing children from exploitation. This extends to abuse, negligence and violence by parents, even if it is justified as an instrument of achieving discipline at home. Further, children cannot be made to work in difficult or dangerous conditions. Children can only volunteer to work doing safe chores that do not compromise their health, or access to education or play. Sexual exploitation, another dimension of exploitation, is also prohibited, as an activity that takes advantage of them. Survivors of neglect, abuse and exploitation must receive special help to enable recovery and reintegration into society. Children also cannot be punished cruelly, even if it is under the ambit of the justice system. Death or life sentences, as well as sentences with adult prisoners, are not permitted. Question 4. Law reflects the socio-political culture of people. Economic, social and cultural rights, and civil and political rights. All human rights, whether civil and political, or economic, social and cultural, are interlinked. For example, individuals who cannot read or write often have a harder time in realizing their full potentials than those who can to find work or to take part in political activity. Malnutrition and hunger are less likely to occur where individuals can effectively exercise their right to vote and influence government priorities. The UDHR, ratified in 1948, makes no distinction between these rights. A distinction later appeared in the context of Cold War tensions between the East and West. This led to the negotiation and adoption of two separate covenants, one on civil and political rights, and another on economic, social and cultural rights. In recent decades since the Vienna Declaration on Human Rights in 1993, there has been a return to the original architecture of the UDHR, reaffirming the indivisibility of all human rights. At the same time, there has been renewed attention to the importance of economic, social and cultural rights, particularly in the context of the 2030 Agenda for Sustainable Development and addressing and preventing conflicts crises worldwide, including the COVID-19 pandemic. Obligations of states. States have a duty to respect, protect and fulfill economic, social and cultural rights. Their specific obligations may be summarized as follows. Progressive realization. States are required to progressively achieve the full realization of these rights over a period of time. Regardless of resource availability, states have an immediate obligation to take appropriate steps to ensure continuous and sustained improvement in the enjoyment of these rights over time. Core obligations that are of immediate nature. That their policies and measures do not undermine access to health care or social security benefits. Use of maximum available resources. States have a duty to use their maximum available resources for the progressive realization of economic, social and cultural rights. Even if a state clearly has inadequate resources at its disposal, it should still introduce low-cost and targeted programs to assist those most in need so that limited resources are used efficiently and effectively. Examples of violations. An individual's economic, cultural, and social rights can be violated through various means. Violations occur when a state fails in its obligations to respect, protect and fulfill these rights. Some examples. Forcibly evicting people from their homes, right to adequate housing. Water treatment facilities contaminating drinking water, right to health. Failure to ensure a wage sufficient for a decent living, right to work. Failure to prevent starvation, freedom from hunger. Denying access to information and services related to sexual and reproductive health, right to health. Segregating children with disabilities from mainstream schools, right to education. Legal enforcement. Decisions of national courts around the world as well as regional and international mechanisms covering all economic, social and cultural rights demonstrate that these rights can be subject to judicial enforcement. The judiciary has a fundamental role in developing our understanding of these rights, in affording remedies in cases of violations, and in providing decisions on test cases, all of which can lead to systematic institutional change to prevent future violations. Learn more about these and other key concepts in the ESCR fact sheet. Our work on economic, social and cultural rights. We strive to strengthen the promotion and protection of economic, social and cultural rights within an indivisibility approach to all human rights. We do this by conducting research and analysis to develop policy positions and advocacy on ESCR, providing policy, technical advice and capacity building support on ESCR, to OCHR's field presences and stakeholders at the country level, supporting the work of UN human rights mechanisms on ESCR and engaging in intergovernmental processes relevant for ESCR, and strengthening partnerships with UN agencies, cities and local governments, NHRIs and civil society to jointly promote ESCR. Question 5. Religion is the opium of the masses. Marx. State how far religion has spread fissiparous tendency in the society. In the mid-19th century, Karl Marx wrote that religion is the opiate of the masses, disconnecting disadvantaged people from the here and now, and dulling their engagement in progressive politics. Religion still has a strong influence, according to sociologist Landon Schnabel, but in a new way particular to the contemporary United States. Rather than making people less political, religion shapes people's political ideas, suppressing of uncertainty and injustice, he said. Schnabel analyzed data from a religion-focused 2004 module of the U.S. General Social Survey, GSS, and more recent surveys from 2008 to 18. He found patterns consistent with Marx's claim that religion provides psychological compensation, but in contrast with Marx's assertions, Schnabel found that this applied more to groups with less social status rather than to groups with less wealth. People in socially disadvantaged groups including women, racial minorities and low-income people, many of whom are quite politically engaged, seek religion in higher numbers than white, well-to-do men, Schnabel said, citing previous research. This is because religion provides disadvantaged groups with resources that compensate for lack of social status, he said. Structurally disadvantaged groups are drawn to this sense that there's something more out there than this world where they face disproportionate hardship and marginalization, he said. Religious organizations that provide such spiritual possibility then step in with moral schemas that shape political views. As a result, Schnabel wrote, contemporary American religion and Christianity in particular suppresses. $100,000 would also be more supportive of abortion rights if it were not for these groups' greater religiosity. Seemingly paradoxical group differences in abortion attitudes are largely a function of religion, he said. Schnabel found similar patterns in attitudes toward specific issues on which some disadvantaged groups are not consistently more progressive, including same-sex marriage, free speech, required prayer in schools, marijuana legalization, and others. In addition to examining attitudes toward issues, Schnabel also looked at political party affiliations. He found that religion suppresses the likelihood that women, Black, Latinx, and low-income Americans will vote for Democrats. According to the data, these and other disadvantaged groups are already more likely to vote for Democrats, but they would be even more likely to do so if it were not for religion. Schnabel notes that religion does not disproportionately shape the political attitudes of sexual minority groups, although these groups face structural disadvantages. Sexual minorities are looking for the psychological compensation and provide meaning and purpose, without the right-wing politics tied up in it. But overall, he said, religion is having a particularly strong impact on people's politics.